The Honorable
Good
Court of Tennessee is now in session.
Sorry, I didn't mean to talk over top of you. Good afternoon. Welcome to the continuation of the March 31st session for the Court of Criminal Appeals at Knoxville. Let me introduce the panel to you. To my left is Judge John Everett Williams from Carroll County, and to my right is Judge Robert Holloway from Murray County, and I'm Robert Montgomery from Sullivan County. Each side will have, as you all know, we'll have 20 minutes for oral argument. If you're the appellant and wish to reserve some time for rebuttal, please let me know as you begin your argument. Now, Madam Clerk, would you please call the next case?
State of Tennessee versus Amanda Dawn Freeman.
Okay. Mr. Wilson, are you ready to proceed?
Yes, Your Honor. May I please reserve 3 minutes of time for rebuttal?
All right, 3 minutes. All right, you may proceed.
Thank you, Your Honor, and may it please the court. Good afternoon. Brian Wilson here with the Appellate Division of the Public Defenders Conference on behalf of Ms. Amanda Dawn Freeman. We are here today regarding a revocation of probation that came out of the Sevier County Criminal Court. We argue that the trial court abused its discretion by misapplying the facts when it decided to revoke Ms. Freeman's probation. And as such, we ask this court to vacate the trial court's revocation and remand this matter for new hearing. Now, Your Honors, because of the nature of this case, I will briefly try to recite the relevant facts here. This is a case where a through line is largely drugs and addiction. Several of the crimes that Ms. Freeman pleaded guilty to were drug related. There were several relapses after she was previously released that led to several violations. At the revocation hearing at issue, there was some confusion that developed over the type of treatment or help that Ms. Freeman had received since she had previously been released. She had been to a halfway house at one point. The trial court had asked her whether she had had the chance to go to rehab, and she had stated that she had gone once, which was in error. The proof during the hearing from TDOC indicated that Ms. Freeman had not gone to rehab. And this information was quickly, the information in Ms. Freeman's answer was quickly corrected by her trial counsel that she had gone to the halfway house, not to rehab. Nevertheless, the trial court referenced this erroneous material more than once when ordering that Ms. Freeman's probation be revoked. The trial court stated that she had flunked out of rehab, that they had tried rehab, that she had gotten kicked out of rehab. And when the trial court said, or when trial counsel told the court that that information was not accurate.
Can I ask you a question? When you use the word rehab, are you saying drug rehab, or can there be other kinds of rehab? I mean, can you be rehabilitated into the community to get a job or to find proper housing or something else?
Yes, Your Honor. However, I think there is a distinction between the treatment or the services that drug rehabilitation would provide, as opposed to something like a halfway house, which would help someone transition back into society after serving time in state custody.
Okay.
And from my own research, the particular halfway house at issue was considered by TDOC as a transitional facility. There were also regulations, I believe, from the Department of Health that define these two, a halfway house and a rehabilitation center, as two distinct institutions. Despite the trial counsel telling the trial court in this case, Ms. Freeman went to a halfway house, she didn't go to rehab, the trial court responded by saying, okay, whatever, thank you, she flunked out anyway. Because a key factor in this ruling simply was not reflected in the record, was not reflected by the proof, we argued the trial court.
Excuse me, did she actually, I'll use the word flunk out because you did, flunk out of the Never Alone recovery program based on the testimony of Robert McGill?
Your Honor, she tested positive for multiple drugs and was removed from the program for the halfway house. And
okay, you're saying that the semantics in the halfway house versus rehab is what you say the trial court got wrong. She did fail or get kicked out of a program for drugs, correct?
She was kicked out of the halfway house. That's correct. But the distinction between these two entities are large enough that we argue that that it should have been considered correctly at the trial court level, that Ms. Freeman did not have a chance to get that type of, or did not obtain that type of treatment that could have dealt with her addictions, and instead of even having that be considered by the trial court, it simply stated that she had her chance, that she no longer, that there was nothing else they could do, and that the only option was to send her to prison for the remainder of her sentence, even though she had never been to rehab, even though she had never been able to get the treatment that she wanted during the revocation hearing, that she made clear at the revocation hearing that she was ready to go and to get better. That simply never happened.
One more question.
Yes,
After the last violation, if I read it correctly, the trial court ordered her to enroll in an outpatient rehabilitation, treatment, and transitional living facility. And I assume she enrolled in and Never Alone recovery program. Is that right?
that's right. And that would be, from the way I understand it, a transitional living facility.
So when you use the term outpatient rehabilitation treatment, that sounds like drugs.
Well, and with that term, yes, when you're dealing with an outpatient rehabilitation facility, typically that would be drugs. I don't believe that this.
No, but the way I read it, she was ordered to enroll in an outpatient rehabilitation treatment plus the transitional living facility. So did she enroll in an outpatient rehabilitation treatment program?
No, Your Honor, I don't believe she did. However, that was not she was never, no violation warrant was issued for a failure to enter that treatment facility. We're dealing solely with.
But if she was supposed to do rehabilitation treatment, outpatient rehabilitation treatment, but she didn't do it because why? Do we know? Was that it? Was there any proof of that?
There was no proof, Your Honor. That was not mentioned at this very brief revocation hearing. It was simply that she had tested positive. She wanted to go to rehab. The trial court stated that she had already flunked out of rehab and that the only option was to return to state custody.
Well, but if she didn't take the rehab treatment, I guess she would have flunked out. I guess it's hard to pass it if you don't enroll in it.
Well, Your Honor, I would argue that that the issue at hand was not her ability, or was not whether she had enrolled in this treatment or not. It was whether she had tested positive and had been removed from the halfway house. I do feel like these two things are distinct, that she could not get the treatment that she needed at the halfway house, and the trial court never mentioned whether the halfway house was an acceptable, would have served as acceptable treatment or not. I would argue that the halfway house may have provided more of a sober living grounds where people could transition back into into society, but didn't provide the type of physical or mental or emotional treatment that could have really helped Ms. Freeman and really allowed her to beat this addiction. Now, Your Honors, an abuse of discretion can occur when the trial court bases its findings on its own recollection of the facts, or when there's proof outside of evidence that is addressed here. In State v. Bohannon, in a restitution case, the trial court referenced a defendant's financial resources, even though there was little to no proof of that in the record, and that was considered an abuse of discretion. In State v. Williams, in a violation of probation hearing, there was a finding that was based on proof that was obtained after a violation warrant was issued that was not really related to the violation at issue in that case. That was an abuse of discretion in State v. Brooks. The trial court erroneously, it used its own recollection of news stories that were tied to the criminal case that was in front of it, and the court abused its discretion according to this court in that case as well. In addition, the Supreme Court of the United States has found that reliance on erroneous facts can serve as a significant procedural error and can invite an abuse of discretion. Here we argue that something similar happened. The proof indicated that Ms. Freeman did not go to a rehabilitation center. She went to a halfway house. However, the trial court said that the opposite had happened, that she had gone to a rehabilitation facility, they had kicked her out, and that and didn't give her a chance to get the treatment that they could have very well served the ends of justice both for her and for the state. And because that revocation was not supported by the proof, we argue that it should not stand, that this is a misapplication of the facts, that an abuse of discretion occurred, and that this warrants a remand to the trial court for a new hearing. If there are no further...
Let me ask you just one more question. So what you're saying, you're here because the trial court says you flunked out of rehab. So you're saying you wouldn't even appeal this if the trial court had said she flunked out of the transitional living facility. Is that correct?
Not entirely, Your Honor. I think the entire notion of this ruling was that the trial court had tried everything with Ms. Freeman and was saying that nothing had worked. And at the end of the day, they had no choice but to send Ms. Freeman to serve. And the broad notion of that ruling was simply, we've tried everything, nothing's worked. And that quite simply is just not reflected in what happened or the proof that was put on during this revocation hearing. And at this point, if this court has no further questions, I will reserve the remainder of my time for rebuttal.
All right. Thank you, Mr. Wilson. General Orr.
Good afternoon, Your Honors. May it please the court, Courtney Orr on behalf of the state. The trial court did not abuse its discretion when it ordered the defendant to serve the balance of her sentence in this case. The semantics of rehab versus a transitional living facility is really ancillary to the issue that was before both the trial court and this court. The defendant had been given multiple chances at probation. This was her third probation revocation hearing. She continued to violate her probation and use drugs. Indeed, as counsel has agreed here, she was kicked out of the Never Alone recovery program because she had twice tested positive for use of methamphetamine within 1 month. And that was the basis of the trial court's ruling, simply that she had been given multiple chances at probation and she had continuously failed to comply with the terms of that probation. And repeated violations of probation can support ordering the service of the balance of a sentence. The defendant is not entitled to a second or subsequent chance at probation. This was not an erroneous assessment of the proof or consideration of facts outside the record. Instead, the court relied on the fact that the defendant had been given 3 or 4 chances at probation, depending on how you count them, and had failed to comply with the terms each time. The court properly exercised its discretion when it ordered the service of the balance of the defendant's sentence. And unless there are any questions from this court for me, we ask that you affirm the judgment of the trial court.
All right. Mr. Wilson, rebuttal.
Thank you, Your Honors. I would contest opposing counsel's claim that this argument that this is all ancillary to the broader issue. In fact, I'm in the state's brief. The dispute here is described more as that there was the wrong choice of words, and the distinction between a halfway house and a rehabilitation facility is one that is broad enough and relevant enough that it was important to have it correctly considered at the trial court level. This is a case, frankly, where the right type of treatment would make all the difference. Ms. Freeman sought treatment, something more than a halfway house could provide. But nevertheless, the trial court stated that she had already failed in completing rehab, and therefore it had no choice but to revoke and order her to serve. And
let me ask you, What was the defendant trying to recover from at the where's the title to it? Never Alone, in the Never Alone Recovery Program?
Your Honor, she was trying to readjust into life outside of state custody, and also try to get some sort of treatment to deal with drug issues, whether it was at that point an addiction to meth or amphetamines. But the treatment, or well, I won't even say treatment, but the services offered at a halfway house were not equal to the type of treatment you could have gotten at a rehabilitation facility. And
was there proof in the record of that?
Your Honor, the record itself, spoke that, the TDOC official at the hearing was asked whether Ms. Freeman had been to rehab specifically, and the official said, I believe she has not, even after saying that she had been to a halfway house. So TDOC at the hearing seemed to make a distinction between the halfway house and rehab.
So was this place officially called the Never Alone Recovery Program?
According to these, yes, Your Honor, it was.
Okay, and so recovery from what?
Recovery from addiction, but from what I understand, this facility did not provide any sort of, or did not provide the intensive treatment that one might receive at a rehabilitation facility. This was much more about adjusting and providing support.
So there may have been some treatment, but not as extensive as you think when you talk about rehabilitation.
Your Honor, I would argue that what was provided at the halfway house was more of a service as opposed to an intensive treatment. It was more of support to say.
So what you're saying is that yes, it had recovery in its name, and the recovery was to recover from drug addiction, but you're saying the services they provided didn't help with that.
Well, Your Honor, the Department of Corrections has to classify this facility as a transitional facility. It's not. It seems distinct from a rehabilitative facility.
Right. But the judge doesn't work for the Department of Corrections. And so if the word recovery is in the name, what is he supposed to think it is?
Well, Your Honor, given the testimony at trial and given what had been said repeatedly by witnesses, by the defendant, by trial counsel, that one would think that the trial court would see that this was a halfway house. It was something distinct from a rehabilitation center.
But was that in evidence, or is that just from the lawyers?
Yes, I believe it was in evidence based on the testimony of the TDOC official. The record indicated that in the middle of this testimony, the judge just spoke directly to the defendant and said, "Is there anything you have to say for yourself?" And that's when this discussion further continued on.
Okay, thank you.
Well, Your Honor, but for these reasons, we believe that this revocation stemmed from misapplication of the facts, and as the trial court revoked probation based on this incorrect information, this ruling should not stand. As such, this court should vacate the trial court's ruling.
Let me ask you this. If the presiding judge will allow me one more question, I'm sorry to come in so late. Let's take aside the difference between the rehabilitation and the halfway house. But let's just say they're not, that we're not even considering that. Did she violate the terms of her probation by testing positive for drugs?
Yes, Your Honor. There was no dispute at the hearing that a violation had occurred.
Whether she was in a rehabilitation place or a halfway house, she, for the third time, has violated her probation.
Yes, Your Honor, there was no dispute of that at the hearing.
Thank you.
Thank you, Your Honors. And for these reasons, we ask that you vacate the ruling and remand for a new hearing. If there are no further questions, thank you.
Thank you, Mr. Wilson. And I want to, on behalf of the court, I want to thank the attorneys participating in oral argument today and using this particular format. Our court greatly appreciates your working with us to have your cases heard virtually. Also want to express thanks to the staff of both the appellate court clerk's office and also the administrative office of the court for their invaluable assistance today in having this hearing go seamlessly. So with that, we are in recess. Madam Clerk.
This Honorable Court of Tennessee is now in recess.